We're fortunate enough to have someone you know as our witness in this exercise, Amy Mashab from ATF. She's pretty apprehensive about this, to say the least. Yeah, the victim, our latest victim. Seated next to Amy is a longtime friend of mine, George Woody Clark, former San Diego Deputy DA, now the Honorable George Woody Clark from the San Diego Superior Court bench. Woody and I have been friends and colleagues and roommates over the last 20 years, doing a lot of things together, including the O.J. Simpson case, so something that's not the highlight of our career, but it was fun. And seated next to Woody is Chris Plourde. I don't know if you know who Chris is. He's a very highly qualified criminal defense attorney from San Diego. Chris has set the world of bite mark comparison or bite mark testimony on its head in finding that people have been wrongly convicted, people that were exonerated by DNA. So I think he's doing us all a real service by weeding those kinds of things out. And Chris is a highly sought after defense attorney. He was one of the defense attorneys in the first Phil Spector trial, not the one that he got convicted on, but the first one. So I need to make that distinction. So, in fact, there's my new business card. If anybody wants them, I think I have about 940 left, and I don't plan on working long enough to give them all out. So, but I think the first thing I have to say is retirement is great. I work about a day or two a week. It gives me a time to go someplace I really like to go. I go to Hawaii, beautiful beaches in Hawaii, waves. So I like Hawaii so much, I got branded there a couple of years ago just so that I would always have to go back there so somebody would accept that stupid turtle on my back. But here's what we're trying to do today, and what you need to understand is this is hard to fake something, to make up something, to teach you something. It really is. And so what we want to do is we want you to understand, if possible, how we think and why we do things the way they do. There's very little technical substance to what we're trying to do. So that's not what this exercise is. We just want to show you the give and take so that either you can help your prosecutors or they can help you if you share some of the materials with them. So in that regard, there are and will be some, what I think are really important materials online. And if anything comes out of it, it's that you'll have access to these materials. The first is a set of briefs and declarations from a case that faced Springer. I think Jose was involved. I think Hal Dedman filed a declaration, and it was a complex forensic science case. So all of those materials are already posted online. And I'll admit that I took a lot of the legal stuff, and then I wrote a generic Daubert brief, I think, putting together some of the best arguments and articles and things like that. The value of that is it's a Word document. And because in law, like a lot of things, there are no original thoughts, so it can be a seminal document. It's only got federal case law in there. But if you're in a state that has a Daubert admissibility standard, you can give that to a prosecutor and he could start filling in state case law to support the argument. So to me, having that as a Word document is probably the best resource that I think I could contribute to this, other than the exercise that we're going to try to do. So I do want to talk, or Amy asked me to do this, said, Rock, a lot of people don't know what briefs are. They're not underwear, okay? They are underwear, but these briefs aren't. A brief is a legal document that puts forth arguments supporting or against a certain position. So it's a legal brief. And so in many instances, these motions have to be noticed or filed ahead of time. So that's what these briefs are. But I hope you'll find it helpful. And we've tried to pattern this exercise or the skit that we're going to try to do after the briefs. The briefs are structured. There's a declaration by Amy, our witness, in there that's just, because in these cases, you shouldn't ever just go to court for the sake of going to court. That's not a fun thing to do, because whenever you go to court, you can either win or lose. So if you don't have to litigate something for legal reasons, that's the best outcome if it's the right decision. So we've built that into the briefs and also to what we're going to do today. I gave you a little handout that just tries to describe what we're going to do. As a bonus, if there's enough time at the end, this U.S. Supreme Court case caused a lot of stir and concern. And so if we have time at the end of it, or if you want to stay and talk to us afterwards, and I know the poster session's right after us, but I think we'll have time to do everything, including talking about this case that creates impression with people that everybody who's involved in any part of the testing process has to testify in a given case if the defense wants them to. So anyway, the recent challenges we've seen to fingerprints, handwriting, and whatever else I'm not aware of, like firearms, the bases, as you've seen, if you've had to go to court, they deal with the Daubert issues. And one thing about Daubert was that it created an opportunity to try to litigate where the defense could try to keep evidence out when there was limited opportunity before that. And so those, as you know, are the Daubert factors, and we're going to talk about them through Amy. But the basis for that challenges were not usually, except maybe in bite marks, that, well, when these techniques were developed, they weren't developed scientifically or they weren't validated. So they were criticisms of how things evolved scientifically. And most of the arguments, if you look at them from a legal perspective, they say, well, you guys never should have been doing this in the first place. If you had done it right in the beginning, maybe you wouldn't be doing it at all. And then probably the most confusing factor that we talked a lot about in the brief, we're going to try to parallel that in Amy's exercise today, this business about error rate. But I think to appreciate the two prominent legal admissibility standards, it's pretty easy to just parallel them and say, this is what Daubert says a court can consider if there's a reason to in deciding whether evidence is admissible. And Fry, which Daubert replaced, had one factor. It happens to be one factor that's contained in Daubert. And that may seem like words on paper. It really is. Lawyers can do anything with words. But here's from a legal technical point of view, because we're just lawyers, we're not scientists, the significance of having general acceptance be the only criteria if you're fortunate enough to be in a Fry jurisdiction like we still are in California is that unless and until the person who's trying to keep the evidence out can show that the consensus of opinion has changed, they don't have a right to have a hearing. And the reason I think that's important is if you go back to the slide that I had earlier, none of the contentions about fingerprints or firearms or any of the current challenges are that the community that does this has changed their opinions about whether it's generally accepted. So in California, unless and until the defense can say everybody's changed their minds about it, which hasn't happened in any of these disciplines, it just hasn't happened, you don't get to have a hearing as a matter of law, because nobody's going to come into court and say everybody changed their mind or most people changed their mind about it. So, and I'll just leave that one hanging up there. If we have time at the end, we'll talk about it a little bit. All I can tell you is there's a lot of chaos in California about what this case means, and I don't agree with it, but I'm retired now, so I don't have to deal with it every day. But I can tell you that there are a lot of people who think it means something way beyond what I know Chris and Woody and I think it means. So let's begin the skit now, and are we set, Judge?
Sweating.
We're just gonna
relax.
We're just gonna stay in our places now. So we're just gonna kind of follow the what you'll see in the brief and what's in the little handout.
All right, no, I'm kidding. I do have to tell you, though, that when I became a judge about 6 years ago, the most difficult decision was, as to my robe, zipper, Velcro, or snaps. The Velcro seemed too loud, and I was told the zippers ruined too many ties, so I went with snaps. All right, this is the matter involving the government, that is the United States of America versus our defendant. I'll note Mr. Harmon on behalf of the government, Mr. Plord on behalf of our defendant, and this matter is before the court today for hearing based on, Mr. Plord, your motion to exclude expert testimony regarding fiber analysis. I'll note I have read your motion. I've read Mr. Harmon's opposition to that motion along with your reply. Did you wish to be heard, Mr. Plord?
I do, Your Honor, and I wanted to at least state my preliminary objection to some of the comments that the prosecutor made that there's no need for a hearing because there's no proof that there's been a change. It would be the defense position that there's been never any scientific foundation to this testimony in the first instance, and I would ask the court preliminarily to take judicial notice of the NAS, National Academy of Science report. It's a government publication, and I would ask the court to take judicial notice of that and have that as a part of the record in this case for the purpose of establishing whether a hearing should be granted.
Is that book that's about an inch thick?
It is. It is.
All right, I'll read that at our 15-minute recess. All right, Mr. Harmon?
Yes, Your Honor. I think it's clear from the case law we've cited and the scientific literature that as a matter of law, the defendant is not entitled to a hearing, whether by declarations that we filed or by live testimony, because trace evidence testing has been generally accepted for decades in this community. In fact, the witness will testify that she has testified in hundreds of Daubert hearings and never had her testing results rejected by a court.
Well, is that relevant to my determination?
Well, in a way it is, Your Honor, because
I would object, Your Honor, to considering these 100 other hearings unless the records of those hearings are launched with the court.
All right, well, let me hear Mr. Harmon's comments, and then
Sure.
I'll deal with that accordingly.
Well, as you well know, Your Honor.
And justly, I might add.
As you well know, Your Honor, judges are never wrong. So just...
Your point is well taken.
So I don't think I need to say anything more. I'll let you decide based on that, Your Honor.
Well, tell me this, Mr. Harmon. Having read the declaration also, I should note I have read Ms. Michaud's declaration, and I'm a little unclear as far as her testimony that's to be offered to the jury in this case, if I admit it. Can you tell me what her conclusions will be?
Her conclusions are, and I'm not a scientist, that she has associated the fiber evidence between the two locations and failed to distinguish one from the other.
Is her testimony going to include any conclusions beyond that?
No, Your Honor.
All right. Mr. Plord, did you wish to be heard further?
Yeah, only that that offer of proofs from this witness is very vague. What does that really mean? What's the significance of that association? I think if a jury would just simply hear that conclusion, they wouldn't know what to do with it. There's no statistical analysis apparently based upon that offer of proof. There's no quantitative statement as to what the degree of the association is, and so I think it really amounts to a little more than speculation. It could be or it could not be, and to that extent, it may not even be relevant.
All right, well, I think in an abundance of caution that because of the nature of this testimony, and I recognize that fiber comparison, hair comparison have been around certainly for a number of decades, but I'm a little concerned about what the exact nature of the conclusions are that the witness is going to reach, at least to offer to the jury in this case, along with this book that an attorney told me I need to read, but I just haven't read it. What is it, the National Academy of what?
National Academy of Sciences.
All right, well, I think just to be safe, I will grant a hearing in this matter. Are you prepared to proceed with live testimony, Mr. Harmon?
Absolutely. Ms. Machad is anxiously looking forward to her testimony.
Ms. Machad, if you'll raise your right hand. You do solemnly swear the testimony you're about to give in the matter now proceeding before this court should be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
All right. If you would state your name and spell your last name, please.
My name is Amy Louise Michaud, M-I-C-H-A-U-D.
And Amy is spelled?
A-M-Y.
Good job. Mr. Harmon.
Ms. Machad, who do you work for currently?
I currently work for the Bureau of Alcohol, Tobacco, Firearms, and Explosives, otherwise known as ATF.
In what capacity?
I'm a trace evidence examiner there, so I analyze various types of trace evidence such as paint, fibers, hairs, footwear impressions, tire impressions, and other types of evidence.
And how long have you worked there?
I've worked there approximately 4.5 years.
And before that, where were you employed?
I worked for the FBI laboratory, or the Federal Bureau of Investigation, in their hair and fiber unit.
And how long did you work there?
Approximately 6.5 years.
Okay. Have you testified or qualified as an expert in a court of law in the field of hair and fiber comparisons?
Yes, I have.
How many times would you say?
I've testified over 100 times. I'm not sure how many of those were actually hair or fiber testimonies, but a good portion of those were.
Okay. Do you belong to any professional organizations in that area?
Yes, I belong to the American Academy of Forensic Scientists. I also belong to the Midwest Association of Forensic Scientists.
And what role do those organizations play in your disciplines?
Well, they're really a forum for scientists to analyze different types of forensic evidence, to come together. Research is presented, papers are given on various topics of forensic science.
And have you given papers in those meetings?
Yes, I have.
And have you submitted articles for peer-reviewed publication?
Yes, I have.
About how many?
Articles, I think 3 articles, and I've also published a chapter in a book.
Okay. Could you briefly describe the techniques that you used in this case?
Yes, in this case, I looked at the fibers on a comparison microscope, which is just basically 2 microscopes side by side connected by an optical bridge, so I can see the known and the question fibers together in one field of view, much like a split-screen television. I then looked at the fibers on a polarized light microscope, which is really just a special microscope that has filters to allow me to look at the fibers under very controlled lighting conditions. And I compared them in all aspects under these different lighting conditions to determine if the known and the question fibers were consistent. And that also allowed me to determine the fiber type. In this case, the fibers were nylon fibers. I then looked at the fibers under different fluorescent filters. I used 4 different filters, and that allowed me to just see if the known and the question fibers reacted in a similar manner, and they did. And then I ran the fibers on a microspectrophotometer, which just really quantifies the color of individual fibers. And then I furthermore did testing on a Fourier transform infrared spectrophotometer, or FTIR, and that basically allows us to determine the chemical composition and further identify the fiber subtype. And in this case, they were nylon 6,6 fibers.
You'll be providing Ms. Machad those spellings for the court reporter later, I assume?
Yes, I will.
Thank you.
Are the techniques and the equipment that you used, are those all routinely used in other similar laboratories?
Objection, Your Honor. Foundation as to personal knowledge.
Sustain.
Do you know if... See, this is some of the silliness. Lawyers can just ask the same question with the 2 words. Do you know if those techniques and equipment are routinely used in other laboratories?
Yes, I do.
And are they?
Yes,
Objection,
they are.
Foundation as to personal knowledge.
Overruled.
You described your observations and a number of characteristics that you used to compare the 2 fiber sources. How would you articulate your opinion or conclusion based on all of the examinations you've described?
I would say that the fibers were consistent or similar in, they exhibit the same microscopic properties and optical properties. And by that I mean they are the same shape, the same size, the same type. And I could conclude that they could have originated from the same source.
Is it possible, based on the techniques and the equipment that you used, to uniquely associate two fiber sources?
No, it's not. Fibers are mass-produced. Textiles are
Objection,
mass-produced.
non-responsive at this point.
Overruled. You can continue.
So therefore, there are obviously going to be other carpets, other garments out there that have the same fiber types present.
Okay, and is it possible to express your conclusion in any quantitative way?
No, it's not.
Okay. Are you familiar with the factors that the court has to consider in deciding whether or not the evidence you've produced is admissible under Daubert?
Objection, irrelevant. It's a legal conclusion.
Overruled. You may answer.
Yes.
And are you familiar with the concept of testability?
Yes, I am.
Could you tell the court what that means to you as a scientist?
I'm going to object, Your Honor. I'd like to interpose a sort of a global objection to this witness's testimony as to general acceptance. And the basis of the objection would be that general acceptance has to be decided and testified to by neutral and detached experts. This is the...
You mean like me?
The government has to put on a foundation, not from the person who did the testing, which is the case that's being presented this time, but there should be testimony as to general acceptance that goes beyond just the analyst who did the work. And so I think this being the only witness, it shouldn't be allowed.
Well, I'll overrule it. I think at this point the witness is simply being asked about testability, and I think that's an appropriate area of inquiry. So why don't you ask the question again, Mr. Harmon?
Could we have the court reporter read it back? I didn't.
I think the burden's on you, Mr. Harmon.
Thank you. Ms. Mashad, in the context of what you do for a living, could you discuss the issue of testability in the context of the work you did in this case?
Yes, I understand it to mean whether the techniques that I used, the instrumentation I used, and the procedures that I used have been tested or can be tested.
And have they?
Correct.
Have they been tested?
Yes, they have.
And how, could you explain, just generally in the context of the work you did here, how those procedures had been tested? Is validation a good word to use in this context?
Yes, a lot of the instrumentation that we use has been validated prior to use, but also the methods that we use date back to comparative biology, which has been around since the 18th century. And a lot of the techniques that I use are also used in disciplines outside of forensic scientists, like the textile industry or other laboratories. And these techniques have been tested and have been published in peer-reviewed journals.
Okay. That gets on to the next point. These techniques have been published for years in peer-reviewed journals?
Yes, they have.
Okay, and you mentioned that you yourself have published 3 articles in this field?
Yes, I have.
Okay. Let's move on to the subject of error rate. And let's just focus on the techniques that you used in this case. Is it possible for you to calculate an error rate for each or any of the techniques that you used?
No, it's not.
And could you explain why that is?
Well, when I think of error rate, I think of like a regularly repeating error. And that really, there are so many variables in what we do, especially in trace evidence, that it's really impossible to establish that. Now, there are many components to ensure that valid results are produced. Some of those components relate to the scientist or me. And in that case, I am proficiency tested and competency tested prior to conducting these exams. There are also components of the error rate that relate to the equipment used. And like I spoke about earlier, the equipment's validated and the performance is evaluated prior to using the equipment. And there's also the manner that in which the tests are performed. And for those, we have written guidelines, both on the national level, we have guidelines, but our laboratory also uses specific protocols. And we have a quality system within our laboratory, and all of my exams are reviewed by another examiner who is qualified in what I do. I think furthermore, so all of these things really ensure that errors do not occur in my examinations. And I think most importantly, you have to remember is that these fibers are still present. So if anyone were to want to retest this exam that I did, then they certainly could do that.
Okay, so just to kind of recap that long answer.
I'm very wordy when I'm nervous.
The
It should be.
The techniques that you use do not have an inherent error rate.
Correct.
Okay, and you described a number of safeguards built in to protect against error.
Correct.
And in the context of the kind of examination you do, the fibers themselves are not altered or consumed in any way, so that having another person, an independent person, re-examine them would also ensure against error.
Yes, it would.
Okay. And I think you talked about some guidelines, and let's move on to the next Daubert consideration, and that is the existence of standards. And you mentioned the guidelines. Are there organizations, professional groups, that meet to establish standards and criteria that play a role in what you do?
Yes, there are.
And could you tell us what they are and how they play that role?
Yes, just to name a couple, there's one called the Scientific Working Group for Materials Analysts, and they write guidelines and protocols for best practices in the examination of fibers. There's also the American Society of Testing and Materials, and then our own lab writes its own protocols and guidelines that we're bound to follow.
Okay, and those are all available to any defense attorney or expert who's interested?
Yes, they are.
Okay. And then finally, and I know you've touched on this, the final question is the question of general acceptance. And you told us about the Daubert hearings never having had your work rejected, and the fact that these articles have been published for quite some time. Is there anything else that you can add to the question on general acceptance, whether the techniques that you used have been generally accepted?
Well, again, these organizations that come up with these standards and guidelines show that it's a generally accepted field. Also, state, local, federal laboratories, international laboratories are all conducting these types of examinations. These types of exams are also conducted in industry as well, like the textile industry, for instance.
Okay, and final question, something that the judge alluded to. Is there anything in the NAS report that the judge is going to fall asleep reading that changes anything you've testified to here today?
No.
I have no further questions, Your Honor.
All right, thank you. Mr. Plord, cross-examination?
Good afternoon.
Good afternoon.
Have you read the NAS report?
I fell asleep reading it.
Fell asleep. Have you made criticisms of that report in conversations with your colleagues?
I may have.
Okay.
I'm sure I have.
Is it your position that that NAS report has no significance to your scientific discipline?
Well, it certainly received a lot of attention in the media, in the general field, and so it is going to have some impact on the field in general. But a lot of the things that they mention in the NAS report really are things that a lot of laboratories are already doing and conducting, so it's not going to affect me or the way that I conducted these exams.
You don't agree with the criticisms of the NAS report as far as the forensic sciences are concerned?
Objection, Your Honor, that's vague. Which criticisms are, I think that's important.
In general, Your Honor.
Overruled. You may answer.
Can you repeat the question, please?
You don't agree with the criticisms set forth in the NAS report as to the forensic sciences? You recognize there were criticisms, first of all?
Yes, there were certainly some criticisms.
Sounds like you were really awake when you read it.
Obviously, any field can be improved to a certain extent. So I think that they brought up some good points about certification, about accreditation of laboratories. So yes, that can always be improved. However, I feel that we have always been working in a very solid manner, and that the criticisms that they put forth really don't apply to me.
Okay, so this governmental study that was done over a period of years, do you think it was a waste of money? Haven't you used those words to describe the process that report was made?
No.
Well, do you think it was a wise use of government resources to study your area of forensic discipline?
I'm not even really sure whether it was a governmental study or whether it used a lot of governmental resources. I'm not sure where the money came from for that particular study, but I feel that it is a flawed study.
Ms. Machado, I now want to kind of transition to talk about some of the work that you did that is being sought to be admitted. And one of the testing methods that you described here was FTIR. That was, I'll use that acronym. You understand what I'm talking about, correct?
Yes.
How long has that been in use in your discipline?
Probably a very long time. Really, I've been using it at least 20 years. And prior to that, some form of that instrument was used. They just started to apply mathematical formulas to crunching the data in probably about 20 years ago, I would guess.
Okay. And the actual instrument that you used in this case, it's relatively new as far as its production and distribution. Isn't that true?
No.
Has there been any, have you published anything on this particular instrument for this particular test?
No, I have not.
Has there been anything published on this particular instrument as to its validity or error rate when it's being used?
I don't know particularly to its error rate or its validity. I mean, certainly its validity, yes, because it's been published many, many times, you know, regarding the, it's getting hot in here.
I'm not sure it's that hot in here.
I'm dying, sweating. Could you repeat the question?
I'll move on. Your background, I looked at your CV, very impressive, I might add, and you're basically you compare one thing against another, whether it's a hair or a fiber or a piece of glass, that type of thing, correct?
Yes, most of the time, and I also identify materials.
Okay, now you talked about error rates. Mr. Harmon, the prosecutor here, was asking you about error rates, and I want to kind of propose and ask this type of a question to you. If you give an opinion that one particular item, let's just say, for example, a hair, is consistent with or could have come from a particular source, if it turns out that that hair didn't come from that person, it's proven by some other scientific analysis, I mean, would you consider that an error?
No.
So your testimony in this case, by saying something could have come from this particular source, may be totally false. It may actually not have come from that source, and it could be proven that, but you still wouldn't consider that an error in the way that you use that term. Is that correct?
No, again, my findings in this case are that it could have come from this carpet or another carpet made of the same fibers.
Okay. And so the scientific discipline that you adhere to, it could have come from this particular source, but it could not have come from that source also. In other words, that conclusion would be equally valid. Is that correct? Is that your testimony?
And it could have come from another source that had these same fibers present within its composition, yes.
Okay. In other words, some other carpet that wasn't associated with my client, the defendant in this case.
That's possible.
Okay. You just don't know the answer to that question. In effect, your science doesn't give you the answer.
Correct.
And if there were, there are some tests, let's just say in the context of hairs, you could do, let's say, a DNA test and prove that it actually didn't come from a source that visually you say is comparable. Isn't that true?
With regards to hairs?
Right, just hairs or even fibers, anything like that?
I don't feel that there were any other testing that I could do in these fibers that would have allowed me to eliminate them. All of the tests that I conducted really included them in the population of carpets that could have had these fibers in it.
Okay. Now, carpeting is not suitable or susceptible to genetic or DNA testing. Of course, you concede that, correct?
Correct.
Now, before, you've been, according to your CV, you've been a hair comparison expert for a number of years. It's a hair fiber versus a non-natural fiber, but you did basically the same thing. Isn't that true? You would go into court, you would testify this hair could have come from, you know, somebody that looked like the judge here, for example.
Yes.
Watch it.
Testified to that. You testified to those conclusions a lot. And later on, when DNA testing came about, they were actually able to show that a lot of hair comparisons were not valid in the sense that the hair was excluded from coming from that person. but people would come and testify like yourself that there was an association between those two items. Do you agree with that?
Yes.
Okay. Now, you've testified in how many cases where scientific admissibility was raised as a concern?
Over 100.
And out of those 100 cases, were any of them appealed to higher courts other than the trial court where you testified?
Not that I'm aware of, no.
Okay. Well, do you know whether they were appealed or not appealed?
I don't know. That's what I mean. I don't know.
Some, maybe the defendant was acquitted, so there wouldn't be an appeal. You understand that, right?
Correct.
Okay. And then some may have been appealed, but you don't follow those cases, do you?
We often don't hear the results or whether it continues on further.
Okay. So you don't know whether any of those 100 cases, all or a portion of them, were appealed, nor whether they were reversed on appeal. Is that true?
I have no knowledge of any of that, no.
Okay. Do you know whether any of those cases were appealed based upon errors in the testimony that you gave?
Correct. Again, I'm not aware of any.
With reference to the work that you did in this particular case, does the validity testing that qualified you to do this type of work, was it blind proficiency testing, or did you know you were being tested?
I knew that I was being tested.
Okay. Do you know what blind proficiency testing is?
Yes, where it's submitted as maybe like a actual case, or you think it's an actual case and you're not aware that it's a test.
Okay. So when you do proficiency testing, you know your work is being checked, and you're basically more careful in the type of documentation you do and the type of work that you do. Is that correct?
No, I conduct it just as I would any other actual case.
Does your laboratory do any type of blind proficiency testing?
No, we don't.
Is that something that can be done in the line of work that you do?
It could be done, certainly.
And one of the reasons it's not done is because the errors tend to come up in this blind testing more often than the type of testing you do. Isn't that true? Has there been a study to that effect?
I'm not aware of that study, no.
So would it be true, based upon your understanding of the community of scientists that are involved in the work that you do, that in general they don't engage in blind proficiency testing, that that's not something that's commonplace?
I don't think it's very common, no.
Do you know if it's ever been done?
I'm sure it's been done before, but I am just not aware of anybody who's doing that.
Are you aware of any publication regarding any blind proficiency testing that relates to the type of work that you do?
No, I'm not.
But there's lots of publications that deal with the proficiency testing and issues relating to that you actually have undergone. Is that correct? In other words, there's lots of other types of validity testing that's been published.
We're not talking about proficiency testing anymore?
Proficiency, validity, whatever.
With regards to the
But
techniques
not
that I've
blind.
used, yes.
So when you give your opinion and talk about error rates, you're really talking about error rates when you know that you're being evaluated, when you know you're being tested under those circumstances. Is that true?
Well, as I said before, the error rate can't be calculated for trace evidence exams.
So the opinion that you're giving in this particular case, would you be able to state any opinion as to how often that opinion would be wrong?
No.
Is there any, well, let me ask you this question. How many different tests did you conduct in this particular case? Different evaluations of this evidence?
I used 4 different instruments.
What's the newest instrument and method that you used in this particular case?
Probably the microspectrophotometer.
Okay, and how long has that been in use?
I don't know exactly. I've been using one for at least 10 years, so I don't think it's not a very new technique.
Has anything changed with reference to how that is used?
Not that I'm aware of.
Has there been any evaluation of that instrumentation as to how often an error can be made by looking at an item and comparing it to another with that instrumentation?
If there has, I'm not aware of it.
Now, one of the things that you do in your evaluation is you take 2 items and you compare one to the other, and you just look at it, you know, visually to see if they look alike. Isn't that basically
Yes.
what you're doing? And then these instruments help you do that using sort of a different way of looking at it.
Correct.
And essentially, you're making a judgment, a subjective judgment as to whether one thing looks like another thing. Is that correct?
It's not really a subjective judgment. I mean, the terms used may be subjective, but the judgment is not.
Let me ask you this. Can two people look at two different items and one person come to a conclusion that they look similar, and one person might look at it and say, well, there are differences between the two?
Well, I think certainly trained examiners have a better eye for these differences. So yes, there would probably be a difference between, say, a person who is not experienced as a forensic scientist looking at them and a scientist who's had experience. They would possibly come to different conclusions. But I think in general, someone who has training in these areas would come to the same conclusion.
In general, and so let's talk about these trained observers, as you use that term. Would it be your testimony that the trained observers, the criminalists, the people that do the type of work that you do, they always come to the same conclusion, no matter what, as to every feature on a particular item, but one fiber to another?
They might call different characteristics different names. Like I might call something light blue and you might call it blue or gray blue or something. You know, so I think they could come to different conclusions in that respect. But I think that two trained examiners should come to the same conclusion if they're using the same equipment and they have the same samples.
Yeah, but do they come to the same conclusion? Light blue versus blue, they might be two different fibers in that particular instance. Wouldn't you agree? There could be a light blue fiber, there could be a blue fiber. They may actually be a different origin.
I still say that if you have two trained examiners and they're using the proper equipment and they're looking at the same fibers, they should come to the same conclusion.
Do they always come to the same conclusion?
I guess if one of the examiners wasn't trained very well, they might not come to the same conclusion, but they should, if they both have proper training, should come to the same conclusion.
In this particular case, you came to the conclusion that the known fiber, meaning the one that was taken from my client's property, his car, was consistent with, essentially, with this unknown fiber. That's one statement that you made. Is that correct?
Yes.
Is there anything else that you can say about that statement as far as the origin of the fiber? Can you state conclusively that that fiber came from that particular source? Is that a positive statement that you can make here in this court?
No, as I said earlier, it could have come from that carpet.
And the same would be true. It could have come from another carpet from some other source. Is that true?
If that carpet was comprised of the same fiber types, yes.
Okay, so any carpet with the same fiber types. And my question now is, how many of those carpets or that type of fiber from that type of carpet exists in the world, in the environment?
I don't know. I tried to contact the manufacturer and they didn't have that information.
Okay. Now, let's just talk about carpets for a while. Carpet is something that, you know, we see it here, there, everywhere. Essentially, this particular carpet was made out of what, nylon?
Nylon.
And is nylon the most widely used product to make carpets in the world?
Yes.
And nylon has a particular chemical structure to it. You would agree with that, would you not?
Yes.
And basically, for our purposes, nylon is essentially manufactured the same way, maybe a little bit different here and there, but basically the same manufacturing process exists with nylon wherever it's made. You would agree with that?
Well, there are some slight differences. There are different types of nylon. For instance, there's nylon 6, nylon 6/6. There are a number of different types of nylon, so there are slight differences when you look at just the chemical composition. But when you look at other factors involved in the fiber, they're going to be dyed with different types of dyes. They may have inclusions in them called, or additives in them called delustrants. So they can look very different. They might be different sizes, different cross-sectional shapes.
Okay. Let me ask you this question. When you have a piece of carpet, let's just say a one foot square piece of carpet. How many nylon fibers are in that one square, would you estimate? Would it be more than 100, more than 1,000?
Mr. Plord, not to pull the rug out from under you, but where are we headed with this line of questioning?
Well, Your Honor, I believe it is leading to this conclusion that the defense would ask the court to conclude, that there's no proof that the science that is being proffered with reference to this testimony can actually establish that this particular fiber came from the location that's being contended by the government. And it is our position that it's pure speculation. There's no way to quantify what the likelihood of a match is between these two items, and that by allowing a jury to hear this information is very misleading. It's similar to the cases that the court is, of course, very familiar with, where hair comparisons were made for a number of years, and various statements were made as to whether this hair came from this particular individual, and then lo and behold, once DNA testing came along, it was shown that those conclusions were actually wrong. That would show what the error rate is. And that's very analogous to this particular situation.
All right,
So,
I'll permit it.
Judge, can I respond to that, Judge?
Pardon? Yes, go ahead, Mr. Harmon.
When the jury sees his client's videotaped confession, they'll know where the carpet came from.
All right, Mr. Plord, you may proceed.
I thought the court suppressed that statement. He was trying to, and I object to the prosecutor's use of that term, confession. My client was trying to assist the police. It's not a confession.
That's all right. At my advanced age, by the time of my ruling, I'll have forgotten that part anyway.
Ma'am, I want to get back to some of the work that you do in comparison and so forth. Are you telling this court, this judge here today, that you've never made an error in any analytical work that you've ever done? Is that your testimony?
I don't feel that I've ever made an error with regards to my results or my final results. I may have, obviously everyone makes small mistakes, whether it's in their personal life or whether it's in their work life. Like, I made a lot of mistakes.
We're not going to go there.
But ultimately, no, I don't feel I made a mistake with the results of this exam.
Well, you are actually, in the statement that you made in your particular report in this case, you're not saying that there is any proof of identity between these two items. Is that correct? In other words, that they are, in fact, from the same source.
Correct. I'm not saying that.
And do you know, for example, or can you tell from the analytical work you did, whether or not this particular unknown fiber was actually collected from the place where it was found, or whether it was it could have gotten there in your laboratory, or could have gotten there through the environment? Hairs and fibers can be floated around and so forth. Can you say that?
Yes, I can, because it was inside of a duffel bag and I collected it myself in our laboratory setting, which is also a very clean setting. We place down clean paper, we clean the tables before we use this, and I feel very confident that that came from the duffel bag itself.
Okay. The duffel bag that was found at the crime scene that you're referring to?
Yes.
And is there any way to...
Your client's bag, then.
Had his name on it.
We loaned that bag to...
The one they showed him in the videotape.
I'll move on.
Wisely.
Are there scientific disciplines that are able to establish error rates?
I don't believe so.
How about DNA testing? Isn't there some error rate published literature in the scientific journals? In fact, one of the journals, the Journal of Forensic Science, that you've actually published?
Well, I think a lot of studies are attempting to answer that question. However, I don't know that anybody could actually give you a number that really means anything. Unfortunately, you can never apply that particular number that they come up with in that study to the actual case at hand. So unfortunately, those really don't have any value.
That's your opinion, that error rates have no value in the type of scientific discipline that you're engaged in?
I don't mean that they don't have any value, but you have to take these studies that are maybe looking at a totally different situation and then try to apply it to a case, especially with trace evidence, because there are a lot of variables involved, like the suspect's environment, the victim's environment. All of those are going to change no matter where you are. And so those really can't accurately tell you what the error rate of that particular exam was at the time that I did it.
Very good. I'm going to move to another subject now, if I can, and ask you this. Do you claim to be a forensic scientist?
Yes, I do.
And what science is utilized in the type of work that you did? What's your scientific method?
Well, there are a number of scientific methods involved in forensic science. Each one of the tests that I performed has its own different method, but ultimately you form a hypothesis of whether this came from the object or not, and you go about trying to prove it, whether it's true or whether it's not true.
Whether it came from the object or did not?
Or did not.
Okay, so were you able to answer that question, that it came from this object?
It could have come from this object.
So you didn't answer the question, did you? You didn't answer your hypothesis, isn't that true?
I misspoke. I'm sorry. I should have said could have come from.
Could
Does
have.
that mean you made an error?
I did. I just made an error.
I'm going to ask the court to take judicial notice of that. Have you misspoke in other testimony on this subject before? Those 100 cases?
Here, you need it.
Thank you. I'm just going to pour it over my head.
So the scientific method that has been utilized by yourself in this particular case, has that been actually published in writing somewhere, what the scientific method is to compare one fiber to another?
The methods used to compare one fiber to another have been published in many different journals over a long period of time.
Okay, so the FTIR would have that test would have a scientific method, is that correct?
I don't know whether the instrument itself would have a scientific method.
Or using that
Using
instrument.
that instrument, yes, you would utilize the scientific method.
And the comparison microscope, that's basically looking at two things under a microscope at the same time, is that correct?
Yes.
Now, you've got some exhibits, as typically most fiber comparison people do, that where you show one and the other under the microscope. Did you do that in this case? Did you take some photos?
No, because it's not a real case.
Well, let's talk about...
But I normally would.
Yeah, let's talk about those normal cases. What you do is you take pictures and you just show how two things look alike, essentially. Isn't that true?
Correct.
Now, there are sometimes things can look alike, but further evaluation suggests to you that they actually are not from the same source. Isn't that also true?
That sometimes can happen, yes.
Okay, so the picture of a particular fiber and it's looking like it might be the same, just visually, different analysis might show that they actually come from two different sources and could not come from the same source.
Right, and that's obviously why we go ahead and further test using the microspectrophotometer and the FTIR and the fluorescence.
So even after doing all of this testing, the comparison microscope and all the different analysis that you did, you can't come to any conclusion that in fact this fiber did come from this particular source, or that this source was the subject of that fiber, correct?
Correct. As I said earlier, fibers or textiles are mass produced, and therefore it could have come from this carpet or another carpet that consist of the same fiber. Characteristics might be consistent to one another. I think that's a better term, or similar to one another, but I think matches, to me, implies that it's exactly the same, and really no two things are exactly the same in my mind, so I try not to use that language.
Do you use the term indistinguishable?
Yes.
What does that mean to you?
That to me means that there are no significant differences that would allow me to determine that two items came from a different source.
But nonetheless, your ultimate conclusion when two samples are indistinguishable is that it could have come from that source, but not to the exclusion of any others in the world.
Yeah, with regards to fibers, that's true.
All right. Any questions based on the court's question, Mr. Harmon?
No, Your Honor.
Or Mr. Plord?
Yes.
All right.
Ma'am, I want to follow up on one of the questions that the court asked, and you used the word no significant differences between the two items. Did you use that word?
Yes, I did.
Okay, so, and I take it that when you use that word significant, that's a kind of a subjective judgment that you made after looking at the two items. Is that true?
Well, it's not a subjective judgment. I mean, like I said before, I don't feel that any two items are exactly the same. So there are going to be difference from one fiber to another. Maybe it might be slightly, but as long as it falls into a range of variations seen within that known sample, then it doesn't have any significant differences. So.
In this case, there were differences between the two fibers. You would agree with that, correct?
No, in this case, they were exactly alike.
Any more questions, Mr. Plourd?
Your testimony that there were no significant differences, and the implication is there were some subtle differences between these two items. Isn't that true?
No. Well, there were no significant differences. The fibers might have been shaped a little bit differently. They might have, or they might be slightly different length, but those differences do not allow me to eliminate it as having had a common source.
The shape of the fiber would be a class characteristic, would it not?
The cross-sectional shape of the fiber, yes, would be a class characteristic. And in this case, the cross-sectional shape was the same.
Okay. Nothing further.
Mr. Harmon, any additional questions?
No questions, just some brief comments, Your Honor.
All right, Ms. Michaud, thank you. You're excused. But don't move. That's subject to recall.
Yeah.
All right, Mr. Harmon?
Yes, Your Honor, just briefly, as the court well knows, under Daubert, the court can rule this evidence admissible for any or all of the factors that the Supreme Court established. In other words, this court could simply say, this technology has been generally accepted for so long that I'm going to rule it admissible, and that's perfectly within the parameters that the federal courts have established. So I just want to summarize what Amy Michaud said so eloquently. The testability, it's clear that these techniques were subjected to the scientific method and demonstrated that they can answer the questions that they're trying to, that they're asking. She articulated peer review articles. I think probably the most confounding factor that has confused a lot of entities concerns the error rate, and I think she was quite articulate in discussing error rate in the context of the court's role at this point, and that is just to ensure that the jury can decide whether she got the right answer. For example, she said there's no inherent error rate, but there are all sorts of safeguards to guard against and detect errors if they occur. But finally, on that point, and I think this is quite a powerful argument, the fact that she didn't alter or consume the evidence in any way. So if anyone were to dare question what she said today, they could simply have the evidence re-examined. I can tell you that hasn't happened. It would be a cold day in hell before they want to have somebody look at those fibers and question what she's done. We heard about standards, organizations, SWIG-MAT. So, but I think in spite of those argumentative questions about the NAS report, she disposed of that in the context of the technology used in this case with one answer, and that was no. There's nothing in that report that changes any issue that this court has to consider in deciding whether the trace evidence in this case should be ruled admissible. So I'd ask you to make that ruling as briefly as possible.
Thank you. Mr. Plourd?
Yeah, just briefly, Your Honor. I think the NAS report was sort of a watershed document that basically came to a conclusion that many of the disciplines, including the one that this witness has testified about, really has not had any type of historical scientific proof that they get the right answer. And I think that NAS report should weigh heavily on the court's mind as to whether to allow this evidence to go to the jury. And I would renew my point that I would make regarding this particular evidence, that without any kind of qualitative association between the two items, it's just really misleading the jury as to the significance of this this item of proof, and that it's really not science because there is no conclusion that one could render other than mere possibility between the two items and their association. So therefore, the court should, after a careful review of the NAS report, should exclude this from being heard by the jury in this particular case.
All right, thank you both. I will, of course, read that report. I'll issue a ruling in fine judicial fashion within the next 90 days.
That's fine.
After I have waded through that inch-thick material.
And can the record reflect that the comments by the prosecutor, how long he has known the judge here over the last 20 years and what good friends he is, and the defendant raises a due process objection that we're not getting a fair Daubert review on this.
So noted. All right. Well, first of all, I'm going to take off my robe. And Ms. Michaud, great job.
Oh, thank you.
So you're going to rule now, right? You're going to rule, right? Yeah.
Rather than actually give you a ruling, which might be inappropriate for me to do with what I do nowadays, perhaps I could approach it from a perspective of what the issues were and what I would have ruled had I been a judge while I was a prosecutor. But having put on fiber evidence, actually the last, I was discussing it with Amy and Chris and Rock, having put on fiber evidence, it was the last real case I prosecuted. In fact, some of the people are here. Tanya Delaney from the San Diego Police Department. Is Faye here, by the way? Faye, there's Faye. Both of them testified in that case, and I'll have to admit, my whole attitude about fibers changed dramatically from before that case to after that case. And as Tanya likes to point out, I never liked to talk to them when they were hair and fiber people because of DNA. Well, after that case, I think I like hair and fiber better. And I think a lot of it was a couple of factors that related to it. First of all, with DNA evidence, you've either got red blood or semen stains or whatever. With hairs and fibers, you have a lot of other characteristics that a jury can actually look at. They can see photographs and see that we're talking about an orange polyester fiber or a blue nylon fiber. Actually, I think it was orange acrylic and blue polyester, or no, blue nylon. Right, Tanya? And orange acrylic. So there are certain characteristics that a lay jury can see. They can't see any differences between red blood or semen stains, so I think that was certainly one of the factors that went into consideration as well. So as a prosecutor, again, in my last case, I was a huge fan of hairs and fibers.
And I do like to use like PowerPoints and show the jury, you know, so that they can see that for themselves.
They were. It's a very visual item. And I also noticed in the context of that case that in examining a hair and fiber, or in this case, fibers in particular, although there were hairs as well, including animal hairs, that in that context, once the results are described, once the photographs are shown to the jury, then the expert's actually able to take another opportunity to recap the whole case about what all of these hairs and fibers demonstrate. So it was almost like a mini closing argument done by the expert while on the witness stand. So it has some unique features to it, certainly.
Time for questions.
Well, would this be a good time? Any questions that we have up to this point?
Let me suggest this. How many of you sat there and said, I don't think I would have answered that question that way? Right? Come on, a lot of you.
Don't be shy.
Or I'm glad nobody ever asked me that question. You know, what I hope, because remember what we were trying to do here was that you probably ask, you should ask us why I did what I did, why he did what he did, because I think that'll give you some insight into things. So I'm hoping those are the kind of questions, rather than saying to Amy, it's pretty damn hard to answer a vague softball like Chris. He's just fishing for you.
In front of all my peers.
And it's pretty hard. You know, I didn't say anything because I told her she was on her own today, and Chris was going to do that. So I hope you can, if you're curious about why we did what we did the way we did it, that you ask it and we can explain it, because a lot of thought should be given into doing this. I didn't spend much time on it because I knew there was nothing he could ask that was going to change what we did very briefly. So.
Mary Ann Stam with the California Department of Justice Riverside Lab. I was wondering, how do you define error rate?
Well,
what would Mr. Plourd's definition have been?
Well, no, and you know what, this is what's interesting, and I spent a lot of time in the brief on this, and we didn't talk about it today, but you know, our legal system is a system of legal precedent. So when a court says something, it came from somewhere, okay? So if you look in the Daubert opinion where they talk about error rate, and there's a footnote there, and the footnote takes you to earlier cases, and I have all this stuff in the brief. Guess what kind of cases they were? They were voice print cases. And if you follow the history of voice prints, you'll realize half the time they couldn't tell one thing from another. And so that was a combination of examiner proficiency and the inability of the voice print technology to distinguish between somebody who really was saying it the same way and somebody who was changing their voice. So there was an inherent factor that was limited by the technology. So if you look at what is in the brief, you'll see that it's just whatever. And people try to make it mean something. And I can tell you, because I've seen this through some of the swigs, when you try to make it mean that, that's what it is, and you're sunk. And that's why we built this series of inherent error rate, examiner proficiency, technology limitations, but ending with, hey, the evidence is still there to retest if somebody wants to. So I didn't answer your question because there is no answer, but if you try to make one, then he's going to have a field day with you.
And the whole exercise, at least from my standpoint, sort of the defense attorney mantra here is that you try to create issues ultimately for the jury. So first of all, you're in a Daubert hearing, and any defense attorney that goes into a Daubert hearing virtually on any discipline pretty much knows he's going to lose. So the idea is not necessarily to win the Daubert hearing, whether it's Judge Clark or any other judge. Typically you're going to lose because most judges are going to let it go to the jury. So you're trying to get something from this Daubert hearing that you don't have. And that's one, you can talk about error rates, see what the analyst says about it, maybe use some of that later, because ultimately you're going to be in front of a jury, and that's where the rubber hits the road, and that's where it really counts. And so, for example, I would bring up error rates and so forth, see what the analyst has to say, and then prepare for the jury presentation and say things like, well, they don't have error rates, they don't have this, and put that in the opening statement, knowing that that's what the analyst is going to say. So that's the defense attorney perspective, that you're flushing this out. And that's where we're looking at. So you don't even need to ask the question. That's an internal question that you ask amongst your working groups.
If somebody responded to you by saying, well, how do you define it? And basically saying, I don't know because I don't know, regarding what error rate means.
Did you get the right answer?
No, and you know what?
Can you prove you got the right answer?
See, I'm not sure if you said...
That's not rate. That's only one test.
Yeah,
see, I'm not sure if you... See, it's perfectly permissible, and Amy's too nice to have done this to Chris, when you have a question like, what's the error rate, to say, could you please define what you mean by that? And so it turns your question into him, and he's not going to come up with anything better than the swigs have come up with. and then it's left for you to explain it. I think if you look at Daubert, it's a combination, and if you look at what I wrote in there, the voice print error rates were something, the known error rates were something like 30 to 50% or 30 to 80%. And all it is, and I'm starting to see this where people are finally acknowledging this, it's just, if there is one, put it out there so that can be considered, and then the jury ultimately decides if you got the right answer. So I think this idea that you have to come up with an error rate or you have to be able to quantify everything, that's playing into the defense's hands. You shouldn't ever do something because they want to do it. Okay, that's fundamentally wrong, because you'll be chasing your tail in that. So
one other thought in that regard as to error rates is, first of all, in real-life casework, who decides if there was an error or not? If the jury finds the defendant guilty of the crime, does that mean that the forensic test was correct? Or vice versa, if the person's acquitted, does that mean the answer's wrong? So determining an error rate in real-life casework would seem very difficult. Now, there are error rates in with diagnostic tools like proficiency testing, But I think, as Rock and Chris have pointed out, that's a dangerous tool without defining what it is that's being talked about.
So,
I think you've partially answered my question. Bill Chapin from McCrone Associates. On a layman's point of view, they look at Daubert, it's explained to them what they're doing. I guess more of it's in a courtroom, but just the existence of having the error rate terminology in the Daubert would seem to be that it would have to have some kind of an answer. What I see and hear is us saying, well, it doesn't apply to us because we can't figure it. I mean, that's
yeah.
taking devil's advocate point of view.
You didn't hear that today, and that's not what I wrote. It's like, if there's information that can be provided, then it should be provided. I have no argument with, let's say, DNA to say there's zero error rate if you do things right. I mean, he's not going to like that. He's probably never going to ask that in a DNA case. It's the other areas that are incapable of quantification that he's going to have a field day with it. And if you try to satisfy that, you'll never appease that beast. Because, I mean, Chris alluded to this too. He's just fishing around for stuff. So when he gets you in front of the jury, he's going to cull out those questions and answers. And if it doesn't come out exactly the way he liked it in the admissibility hearing, he's going to hit you with that. So that's why you really have to be careful winging it in response to questions, because he really had no goal in there except to feel around and pounce on you if you seem to misspeak, and then probably pick out one of those questions about making a mistake and just hit you with it out of the blue in front of the jury. And it's all okay. It's all part of the game.
One other thing, too, is that the answers regarding error rates and whether there's anything published between the admissibility hearing and the trial, if there is something published on that she wasn't aware of that showed an error rate, you know, she'll just be clobbered with that. You know, here it is. You know, you don't know what it is.
But see, let me just go back to, and I think you'll see it clearer when you read the brief. It's the error rate if there is one. That it doesn't say you have to have one. Okay, and if you look at as I said, you peel back the onion and look at the cases that created that concept before Daubert, they're all voice print cases. So if error rate, if it has to be single digits, well, that's not what the voice print case is. So it doesn't have to be anything that it can't be. I know it doesn't make sense, but we didn't make that rule up. They did, and you know, without thinking about it. But it sounded good to them.
Mm-hmm. Well, and if you look at that study, they actually did their error rate based on casework samples. So yeah. I don't even know how they knew whether they were right or not.
If you're interested, we delved into this, and we got the underlying studies going back decades. You go, you need to understand, this pretty crude, really unhelpful stuff, but it's okay. Because that's what it is what it is. Who was I talking about that? It's my favorite phrase anymore. It is what it is. But if you try to make it be something that it's not, you're in trouble, because he's going to have a field day with it.
If there's anything published on error rates and regarding fibers, then that can be used. And let's just say it's 80%. Well, you can get the right answer if you flip a coin 50% of the time. So, I mean, what is the error rate? You know?
Well, see, that's where the retesting comes in. You go, wait a minute, are we going to guess whether you got the right answer when the guy's life is at stake, or it's
the government. This misleads the jury when you talk about that.
So,
yeah, smoke and mirrors.
Thank you.
Hi, I'm Helen Griffin from Ventura County. I would really appreciate any recommendations you can give regarding the issues of 2 points. One is the proficiency testing, the blind proficiency testing, and how that would be addressed in court. The other recommendation I would like is on this whole issue of the fact that we work for law enforcement, and it's perceived that we're biased because of that. So I'd like to know how to address questions regarding those 2 points in court.
I honestly, those are relics of when Woody and I got started in this field 25 years ago. Honestly, I don't see a problem with it. I kidded around with Amy, when you have a good witness, you do something really brief like I do and say, all right, you're on your own, but we've talked about what the issues are, and you don't have to answer. You know, I could tell you feel kind of dirty when you see Amy being asked questions about that, but you know what? You're the only one. Just somehow that makes you feel vulnerable, and it shouldn't. Juries don't see it that way. Proficiency tests are whatever they are. They should be routinely discoverable. I remember 25 years ago, we discovered, remember how the proficiency test played a role in the conventional serology stuff. It was a secret from the legal system, but you know what? Most people don't make mistakes. That's a good thing. So, and actually one of the articles I alluded to in the brief is a recent article by Bruce Bedoli in the journal Forensic Science. There's tremendously helpful stuff in there about all this stuff, and there's a lot of work went into it. I think it's responsive to the NAS report in some respects, but it covers, there's a tremendous discussion about proficiency tests being remedial, and they are certainly not a reflection on what you did today. That lends itself to the retesting point. So I just think you have to realize you're not the whole show in these things. You're just a part of it. And you may not like being asked questions by a guy like Chris, but I can tell you there was nothing of substance that he asked her that I would have bothered objecting to in front of a jury.
The blind proficiency testing, the issue is you don't do it, not that
right.
It's better or worse. I mean, thinking about it, why don't you do it? That's sort of what the argument would be in front of a jury, because you don't really want to know what the result is, and you know, to the extent that the defense attorney makes the argument, you know, hey, they don't know whether they get the right answer or not. Like all the questions with reference to whether the fibers in fact came from the same source, which she really never said that they did, all that is just to set it up for the jury. You wanted to pin her down as to that so you can then ram that home and prepare for that at the time of the trial. So it had nothing to do with the Daubert issue. You're just using the Daubert hearing to gather that information to set forth your case, you know, that you're going to eventually present to the jury.
Good afternoon. I'm Steve Morgan from the University of South Carolina. First and foremost, I'm an analytical chemist, and second, perhaps an applied statistician. I greatly appreciate the judge's comments about error rate and what does error rate mean, and perhaps it's not applicable. As a measurement scientist, I think we all think about error rate in different ways. Philosophically, there's a difference between accusing somebody of an error and discussing the uncertainty of a measurement.
Right.
And Amy was right on target when she, in one of her responses, said, in regard to subtle differences, that there were no significant differences. And what I think she was referring to was the fact that within the variability of measurement of the samples, there were no differences outside that variability. And so it's always a signal-to-noise ratio issue when you're talking about differences. And the signal-to-noise, you know, varies from comparison to comparison. Second comment I would have is about class evidence. This is all class evidence, and so these characteristics that we're measuring are common to many different materials. And the problem in determining error rates with class evidence is that you need good population statistics. And there's been many studies in certain areas that establish, you know, certain measures of population statistics. So you can say in this population, there might be a certain percentage of the samples that have this characteristic. But then again, fibers, as many other class evidence, it's a moving target. The population is entirely changing. In the case of fibers, textile companies are moving offshore to foreign sources, and things are varying all the time. And so the idea of getting a really good population idea of different characteristics is extremely difficult, and extremely difficult to you know, talk about the random chance of a match in that situation. And then finally, to repeat something that we heard from Vince Desiderio and other people, use as many analytical methods as you can. The larger the number of characteristics you look at, the less likely it is that all those characteristics are going to match randomly. Now again, it's very hard to talk about error rates in this situation, but you can do the sort of quantification I understand they did in the Wayne Williams trial, where they're able to actually determine some population numbers and quantify what's the probability of walking into a random house in Atlanta and finding this blue nylon fiber, right? But in regard to fibers, using different analytical methods, and looking at as many characteristics as you can, if they all are within experimental uncertainty, then you've decreased the probability of a random match. And I think that's something that everybody talks about. I think Amy was voicing that when she was defending herself there.
And jurors appreciate the effort to distinguish failing, and common life, common experiences really do help them appreciate the power of that much more than you could try to articulate and then have Chris attack it. I didn't hear the duct tape talk this morning, but I talked to somebody who was there, and it sounded like it was very impressive because of recognition of not being able to determine uniqueness, but being able to compare so many different factors. So it's something jurors really appreciate. But one thing that, how many of you ever watched a whole trial that you participated in? You're probably not allowed to, and you're too busy to do that. But, I've been dealing with Steve Velsko from Lawrence Livermore Lab in microbial forensics, and he's a pretty high-powered scientist, and try to tell him, you're not the star of the show. You have a role in there. There's a certain we're not going to win when you leave the courtroom. There's a whole... No, there's a whole process. And the point of that was just to say what you can say. And it's either enough to sustain a conviction or it's not. Presumably that decision was made before the case was charged. So there's really no need to overextend things. It gives guys like Chris a longer career than he's already going to have, by doing that. And so there's really not a need to do that. I know for the most part that's what everybody does, especially government criminalists get underappreciated. But that's what we've learned. Woody's case is a perfect example of it. The Westerfield case. Next question.
Let me just say thank you all for this wonderful presentation.
No, it was hard. I mean, Chris was straying into stuff that we didn't talk about, and so. But and let me just comment on something. This is just a hearing to get it before the jury. So I didn't talk about her results or show anything. We're not trying to convince the judge she got the right answer. That's not the goal of this. The goal is to just say, I met this threshold. The jury thing is a whole different show. So.
Yeah, I just wanted to, Daubert from the RCMP lab in Edmonton. I just wanted to make a couple of points and ask a question. I guess the first point was in relation to maybe error rates on fibers. Even though it's hard to define, I think one way of approaching it might be to look at target fiber studies that have been done in Europe, mainly in Europe and Britain. They've done a lot of work over the last 30 years in doing a lot of target fiber studies. They're similar to saying, okay, I live in a certain environment. If I go to my neighbor's house and I choose, say, what I'm going to do is go look at their house and try to find a blue sweater that matches my blue, something blue in my environment, and find out how often I can do that. And they found through a lot of studies that, at least for colored synthetic fibers, it's going to be a very rare occurrence where you're going to get a coincidental match between two sources of fibers. Now, that's very hard to quantitate because each study comes up with different results, specific results, but the actual general results in the end and the conclusions are pretty consistent that, at least for colored synthetic fibers, the chances of a coincidental match are very low. Now that, of course, doesn't tell you anything about that specific case, and that's why we have to always say, these fibers either came from this source or another source of indistinguishable fibers. But at least you can give the jury some idea that, at least for synthetic fibers, chance of getting a coincidental match through all these studies have been shown to be fairly low.
And I've certainly testified to that, before, talked about some of those studies before, but I just felt like when we were talking about error rate, I didn't want to go there because
Yeah.
I didn't really want to imply that any of those had anything to do with this particular case at hand, and I didn't want to have to answer any questions about what the error rate was of this.
Yeah.
Good
this
choice.
exam.
Yeah.
So, but I agree. In my normal testimony, I will oftentimes, talk about those studies.
Yeah. But I guess my other question is, when they started, I guess one of my concerns about the way things have been progressing as far as Daubert hearings and that, is, are you finding there's going to be a tendency to disallow trace evidence if we can't say one way or another whether it came from a specific source? Because that's what I'm worried about, because trace evidence was never meant to be a smoking gun. Right. And I guess what I'm wondering is, what's the difference between us going in saying we've done all these observations, whether they're instrumental, microscopic, or whatever. We've made observations, and in our best determination, we're saying these things are indistinguishable and they could have come from this source. What is the difference between that than having someone come off the street and say, yes, last night I saw a 6-foot man, heavyweight, wearing a hat, but I didn't see their face? That testimony never seems to be.
Let me try it. You gotta
see where I'm going with that, or?
No, his job is to help serve his client. Okay, and so if there's a mechanism for him to undermine or emasculate my case, that's what he has to do. He's supposed to do that, and he's a pretty smart guy. Strategically, he'll evaluate his chances, and I mean, there's a lot of thought given into that. So the fact that there are hearings relates not only to the legal system, provides a mechanism for him to challenge whatever is offered. It doesn't reflect on you guys at all, or anything you do.
It's always going to come into evidence.
So, as you've seen in other disciplines, law professors seem to have divvied up forensic science, and they've each mounted these challenges to it. So I attribute it more to, there's a law professor that needs to write a bunch of things, and he's got a bunch of law students working for him. These are self-generating things. They arise out of law schools for the most part. And so I don't think you should feel bad when there's challenges. And they don't intimate that ultimately this stuff's not going to come in. There's absolutely no relationship between the strength of the results and whether or not they'll come in or not. That's not, you won't see that in the factors. I didn't ask her much about the results. We just talked about them in general terms. So as you've seen, if you're like Cassandra and I were talking this morning, you get some knucklehead judge in Maryland deciding fingerprints are inadmissible using an admissibility standard that doesn't exist in her state, So, but yeah, I guess the point is, you're better off betting on horses than trying to derive messages from the legal system. Or predicting trends or anything like that. It's just whatever happens, it happens. And whenever there's wasn't that in the NAS report, the Baltimore fingerprint case or the Maryland fingerprint? Yes. I think it's in the NAS report.
It was in the Brandon Mayfield case as well.
Yeah, so anyway, Mark.
Mr. Harmon, my name is Mark Stollerow. I'm with the National Institute of Standards and Technology, Office of Law Enforcement Standards. I found this panel discussion to be illuminating and exhilarating today.
We're sorry to wake you up, Mark. That was the previous group.
I have a question preceded by a comment, and then the question returns to that element of Daubert dealing with error rates. I think all of us are concerned about what error rates are, and in particular, going back to VoicePrint, the fact that VoicePrint in California set the table in many respects for Kelly Fry. In fact, Kelly was the VoicePrint case. And when Daubert was decided, again, it was there were references made back to the high error rates in VoicePrint and the lack of reproducibility or reliability that led to the inclusion of the element of error rate for the gatekeeper. And the question that I have is confirmation, asking if this is correct, that Daubert wants to know whether the science that's testable has about its science that an error rate can be determined for that science. They're not asking the question what the error rate is. They're asking whether or not an error rate can be determined for that particular science. Is that correct?
No, I don't agree with you. There's a couple of things that I don't quite agree with you. If you read Daubert, I don't recall it says these are voice print cases we got it from. It just gives the cites to the cases, and you have to look at those cases and go, wait a minute, these are voice print cases. Yes. And in those cases that predated Daubert, that high off-the-scale error rate didn't doom its admissibility. The voice prints were admitted in spite of this technology's virtual inability to provide much confidence in the results. So I think it says the error rate, if any, and so you provide whatever there is to provide. I think little thought was given to it.
All right, well, and I agree with you. I don't think Daubert, I don't recall, I don't think Daubert specifically mentions voice print. I meant in the evolution of admissibility hearings, going from Frye to federal relevancy to Daubert into variations like Kelly-Frye, Davis-Frye. These all evolved as a consequence with impact that reaches back to voice print. But the other question in terms of whether or not a particular science is susceptible to a measurement of error rate is the point, rather than what is the error rate. And many of the sciences for which forensic scientists give testimony, expert testimony, don't have any error rate which has been determined for the class of evidence which is about to have testimony given. The question they're asking is, can this science have an error rate determined for it, which means there's some level of reproducibility, there's some level of uncertainty, some level of variation which can be measured.
Can I ask you a question? Am I reading into your question that you've committed a lot of resources to trying to identify the error rate for all of these things?
Well, that's the next question that I have for you. The NES report has said, in effect, the NES report, thank you for the softball. The NES report has created an additional emphasis on
a challenge to the community.
Exactly, and among other things, they're saying you're giving testimony in arenas which, even if valid, don't have a great deal of highly scientific, published, peer-reviewed validation studies that demonstrate what the uncertainty is. And uncertainty is a form of error. It's part of the concept of error. It's really a measurement issue rather than an error issue. So if you're going to do a test, number one, what's the measurable uncertainty in the test you're doing? And of course, it varies from the quality of the evidence and the conditions under which the test is being administered. And the second is, based on the uncertainty that you determine for that science, what conclusions are appropriate for that level of uncertainty? And these are questions that are reasonably good questions that are going to be addressed or need to be addressed. And there is certainly activity in a lot of different arenas now, congressional level, federal executive level, to try to develop a means to address these issues. And we have a panel tomorrow to discuss that in greater detail. One of the things I wanted to ask is that, given the track record of challenges under Daubert to general reliability or general admissibility of evidence over the last 15 years, what I gather from the defense community in their excitement about the NAS report really isn't to throw out the entire science or discipline as inadmissible or unreliable, nearly so much as a door that opens for the defense to challenge the weight of that testimony in a given case. And I know that this panel was directed specifically to Daubert hearings today, but if I could ask you to comment, Chris, how much additional ammunition or opportunity does the NAS report and the focus that the defense community has given it empower you or enable you to challenge evidence of this type in actual cases in terms of weight that goes to the jury?
Yeah, I think you've hit the nail on the head. It really goes to the weight, and it's something we didn't have that before that we have now. It's something that shows uncertainty or raises questions, and it's a, it's somewhat of an official pronouncement. National Academy of Sciences, it sounds important, sounds like they know what they're doing, and when you bring that up in front of a jury, and it's been in the media, there have been questions about it, and you draw analogies, it lets you argue that the significance of this testimony is much less than what the prosecutor is making of it. Now, keep in mind, I've been doing this for quite a few years. When I started 25 years ago, I mean, there were comparison experts that did quantify things, that did take it too far, and they were challenged and so forth, and they've backed off of that, obviously, as we all know. That's the wreckage of your past that we don't talk about at these meetings, but the reality is that there used to be people that gave numbers, gave statistics. Some people still do that, but they're in the minority now. But the the report, I think, really hits that hard, so that can be knocked out. I think that would be subject to a lot of challenges.
And Mark, I know there's a lot of momentum gain to address stuff that's in there, and I got to tell you, you heard the best that Chris could ask about it, argumentative questions. That there's nothing. I cannot imagine, like in a case like this, bite marks, yeah. In any other forensic discipline, I would love to see the questions, the specific lines and sentences that people could use to undermine it. And honestly, you know me for a long time, I think that if the scientific community starts chasing its tail to try to address the stuff that's in a fluff report that has you have to remember, the whole premise was that Daubert, and this is a whole other talk I'm giving next month in Texas, the legal section is a disgraceful, biased account that justified the need for science to fix things because the legal system isn't the right place to handle it. And so I think if there's a lot of resources committed to trying to do something that you can't do, that's what's going to give him a 5-year run at this. And I know that's the history of all this stuff, but I just think what you're doing puts off anything meaningful today or tomorrow or for years until you finally do it. And I've seen it happening, and this stuff's all coming to us. We're the lawyers. We're saying everything's okay. Has anybody had the NAS report bite them in court since it happened? If you're a bite mark guy, yeah, you're but it just so, and even your articulation of the error rate stuff, it's a very elusive concept that means different things. We shift from precision to proficiency to inherent error rate. And that's why I dusted off an old article that Jim Woolley and I wrote in the American Journal of Human Genetics.
Sure.
And it's in my brief. We spent a lot of time quibbling about things that can be scientifically determined. So why don't we determine them scientifically? Because we quibble in court. That's what his job is, to quibble with me and me with him. So, but as I started reading the NAS report, I said to myself, if you do all those things, is he going to go away? And the answer is no. And so if that's not the purpose, then what is it?
But there certainly are opportunities with the NAS report to bootstrap the science and provide additional resources for research and for funding, for determining uncertainty rates and a number of other things that we'll cover tomorrow, which are beneficial to the science in addition to the law.
Absolutely.
But I think you highlighted two key things, and then I'll shut up and sit down. The one thing is that over the last 15 years, there have been thousands of challenges in criminal courts to Daubert. I think there are half a dozen instances in which there was a ruling which was against the admissibility. So it's a very rare event. Second thing is that if you look at the examples of individual cases where it resulted in an appellate reversal, in most of those instances, those of us in this room can be embarrassed by the forensic testimony that was given.
Yep.
It was an anomaly, and it was on the extreme end, saying things that shouldn't have been stated, or making claims, or giving probabilities that weren't justified by the underlying science. And those are the ones that are cited in the NAS report.
Absolutely. Right. Absolutely.
So those are the only two additional comments I wanted to offer, and I'll sit down.
What are we doing for time? Can we go a little bit more? Okay. Can we talk about, let's just have one more question, and then we want to talk about Melendez-Diaz for a few minutes, just to give you our take on the thing.
Guy Nutter with Michigan State Police. It's a quick one. Just along that NAS report where they talk about us working for law enforcement and biased.
It's embarrassing, isn't it?
Yeah.
I'm just, the arrogance of the people that wrote that out of some anecdotal experiences. I put off reading it for a long time, and there you hit, and juries don't feel that way about you.
Yeah, and that's
you know that. Yeah.
Just going to ask you to nip that in the butt. Do you see any value, or did you ever in the past talk to a scientist that's on the stand about how many times they eliminate a suspect? Because that stuff never really goes to trial once we eliminate it, and it's never heard of, but it might kind of nip that in the butt.
You know what? If I could find the O.J. Simpson video, it's one of the few things Marcia Clark liked that I did when Gary Sims was testifying. He used to be in private practice, and so I said, have you eliminated people? Yeah. How did you feel when you eliminated them? It's a great question. Huh? You feel the same way as you do when you include somebody. I just was winging it that day, and she thought she was in the middle of her coffee. She thought that was great. So no, it's just that thing's appalling, and it's just hard to believe that it's going to cause so many limited resources to be spent trying to address something that never should have happened.
And I think that latest paper by Badoli actually addresses that bias quite a bit.
Yeah. No, has anybody read the Badoli article? It's long. They put a lot of work, but there's pretty good stuff in there. It's, they put it in his last days at the FBI, they cranked that out.
It's in the latest JFS.
Yeah, let me give you the defense attorney twist on this, because there always is one. That very point, my experience is that, the atypical forensic scientist that works for a crime laboratory, he's usually probably the better person to do the type of work, because there's unique issues in crime scene analysis work than as compared to other independent scientific work, and whether it's medical or otherwise. But so the reality is not what we're dealing with. We're dealing with the defense attorney trying to convince a jury that maybe this scientific opinion isn't as good as the normal scientific opinion, and then the NAS report gives us some fodder for that. So in a real case, in the real world, you get 12 people on the jury, and let's say you pick someone whose husband is a research scientist or something, or they have a relative that's a research scientist. Well, that rings very true to them. Well, independence, that's a big thing. So that it's not like it's irrelevant. It's something that we're going to use in our quiver and pull out that arrow to deal with, what weight do you give this particular testimony, et cetera. Issue of bias, especially when you have crime laboratories that are operated by the district attorney's office. They're people. They're prosecuting the case. I use that all the time. Hey, if the jury doesn't accept it and they don't think that that has any weight, so be it. I've lost nothing, but I've raised the issue. Sometimes jurors are bothered by that. Not all the time, but sometimes. All you need is one. So.
Oh, okay, let's move to this. Now, is everybody familiar with the case? I'll tell you a little bit about it. Anybody has no idea what Melendez-Diaz is? Okay. Our Supreme Court decided a case recently, and the process is a case from Massachusetts, and I learned something. I was surprised at what they used to do in Massachusetts, but they have a statutory mechanism that for drug analyses, and I've learned that other states have similar ones, and I've got to tell you, we litigate everything in California, so to learn this, you go, wow. So they go to a notary public, and they fill a little one-page thing and said, this is heroin, it was 3 ounces. That's pretty much it, okay? And that is, by statute, that is prima facie evidence of the proof of what's stated in there, which means that alone can be the proof of it. Now, that doesn't mean the defense attorney can't call the analyst if they can establish a reason why, things like that. But so the defense attorney objected, and this whole process went up to the U.S. Supreme Court, and a little while back they issued the decision. And so, and it related back to some earlier cases. And so there's a very limited question that the U.S. Supreme Court addressed, and that is, does that piece of paper deny the defendant the right to confront and cross-examine the expert? And you know what? The answer had to be, and is, and always was, yes. I mean, you can't, I just don't know where that process came from. Other states have a variation. You may be from one that if you want the analyst to testify, you have to tell the DA 30 days ahead of the trial. Has anybody got a statute like that? See how, what state are you from? Utah, you know, Colorado has one. And that's not an issue. It's because if they say, it's okay to say, you got to decide 30 days ahead of time. So this whole mess came out of this limited question. Now let me explain the process, because I think when you understand how these guys operate, you'll appreciate why you're confused about what they said and what it means and what we're supposed to do. Somebody gets charged with writing the opinion, and then they circulate it around, and they all look at it. And sometimes they all agree, sometimes they don't. Okay, so this one clearly, it was close. There was a majority opinion that agreed. But then the group that doesn't like it, they get together, and they start writing their dissenting opinion. Now, the guys that wrote the first opinion that started it get to look at the dissenting opinion. And, you know, the egos are pretty big in this, because this is the U.S. Supreme Court. So these guys don't want to be showed up by something that these guys have raised, so they get to change what they started out with and get to dump on the points that they raised. Because if you read this and just read it literally and not think about how did these guys know what these guys were going to say, that's the process. So, and I just called out, here's all this from a legal significance, legal precedent point of view. It just says you can't do that on a piece of paper. That's about 4 or 5 or 6 pages in. Okay, that's all, that's the only legal issue. There's a term, a Latin term in law school, all the other stuff was dicta. It's just talking about other stuff that's not germane to the decision. This is all they decided. And then, you know, because they were a little put out, these guys raised all these issues. Now, this is the guys that started it are rebutting the rebuttal that started it. And so everything that people are concerned about are responding to some of the bad arguments that the minority made or the dissenters made. And so the idea that there can't be a business record exception or anything like that, or the notion, and I can tell you from, you know, I work part-time in San Francisco DA's office. They're all thinking, hey, we got to call everybody now, and go, all right, if that's what you think, I'm retired. I work Mondays only, and so I won't be there, but how are you going to pay for it? we might as well close down our cold case programs on homicides because all the pathologists are dead if the case is 15 years older or more. So, but, you know, you get a bunch of smart people together and, you know, some people are cup half full and some are cup half empty. And if you see problems, you have to come up with solutions. And if I think the pathologist deceased example is the thing that starts opening people up. Say, oh, no, that's an exception. And here, Chris, and can you talk about this, Woody, or?
Maybe not.
Okay. I think that sparks the discussion because here's the idea that's behind this simple ruling. They are entitled to ask about what happened. And so in the context of a pathologist, he's going to review a government record, he's going to review lab work, and then he's going to form his own opinion. And his own opinion is based on all this other stuff. And so he could be cross-examined to his heart's content about that. And I think that discussion starts opening people's minds up to then say, okay, what's the difference in a DNA case when you get the lab supervisor and a couple other people did the work, or hair and fiber? I just think affording the defense an opportunity to have some qualitative cross-examination about the work that was done that you're testifying about, even if you didn't do it, should suffice. And I know our state, we have a state Supreme Court decision that predates Melendez-Diaz that's totally in conflict with Melendez-Diaz. It's a DNA case. I think it's the best kind of case to have this kind of decision made on. They've taken up a couple of other cases, so I think our Supreme Court is going to come out with something that's not in conflict with it, but that explains it away and leaves this standing. Yeah, you can't do it on a piece of paper. They're entitled to ask questions. But how many of you are getting this idea that everybody involved has to testify? You know, DAs are great sometimes. Their problem becomes your problem, and if you can't solve it, they don't have a problem anymore. But that's kind of the state of chaos that I've seen, you know, even in where I used to work in Alameda County and in San Francisco. And I just think it's people that haven't thought it out very well. But, and I was told there was an article in our legal newspaper by the Stanford law professor who was involved in the case who said, hey, we didn't think it was going to have these wide-reaching implications because it's a very simple issue. Can you put a piece of paper in there when they want to ask questions about the person that did the work? So, Chris?
I would turn one of your arguments, you know, around. In that particular case, you know, they put the piece of paper in that said it was this narcotic, but they could have, the defense could have retested it, so why couldn't they just let the paper?
Well, you know what? And they actually specifically rejected that. I was disappointed that it's a good argument, but they said no. In fact, what they said about that was just because there's an alternative solution to it doesn't mean he's not entitled to confront, cross-examine a witness. So it was probably a bad case to inject that in. But what do you think, Chris?
Well, I think that the reality is that, you know, defense attorneys are going to try to expand this ruling. I mean, there's all kinds of statements in that opinion that are ripe for interpretation, and a lot of them are dicta, meaning that they're not really related to the holding in the case, because the holding is very, very narrow. And it is what Rock just explained, is that you cannot put into evidence an opinion basically without a witness. That's essentially what it means in layman's terms. And you've got to afford the defense the opportunity to cross-examine. Now, does that require you to put everybody within the chain of custody on? I don't think that's what this case means. In fact, there's some language in the case that says otherwise. If you testify on a particular subject, and as part of that you're relying on statements or opinions of other people, like a pathologist or even, you know, other people, you know, other disciplines, you know, can you bring in or bootstrap other opinions into yours? That's a gray area to some extent. It depends on whether that's part of the analysis or or is it essential to the analysis? And does the defense have the right to say, look, if that opinion is pivotal to your opinion, then maybe you do have a right to that?
Okay, well, it looks like we covered everything. Thank you. It's been a pleasure for all of us except Amy. Yeah. Oh, no, you did good. Yeah. Yeah.